SJC-11043, Commonwealth v. Jerry Meas.
Thank you.
Good morning, Your Honors. May it please the Court, Attorney David Mirsky for Jerry Meas. There are multiple significant issues that I'd like to address, and if there's not time for all of them, I don't intend to waive anything, and I would like full consideration of all the issues that were briefed. First of all, I'd like to address the matter of the show-up identification.
Yes, can you tell me how much time passed between the shooting and the show-up?
It appears that there was time enough. There was time enough for two of the witnesses who were to be taken from the police station to the show-up.
Well, are we talking an hour?
I believe it's an hour, but I don't know exactly the exact time, Your Honor. The point is, there was a whole operation set up.
I thought that the judge said that it was within 1 3/4 hours after the shooting, that the 4 witnesses identified the defendant after a series of show-up ID procedures, so that we know that an hour and 3/4 apparently passed between the shooting and the time that all of the identifications had been made.
Well, I don't know anything to disagree with that, Your Honor. I think that the important thing is that what happened here was that a whole procedure was set up out on the street at Queen and Branch, I believe, that could have been done at the police station, that what we had was overwhelmingly suggestive, that there's a photo that I didn't have a color copy of, but the Commonwealth presented.
Well, haven't we said in the past,
And this isn't, excuse me, Your Honor, but this is not the full size. The picture should be this size. Okay, and I believe it would be important for the court to see the actual exhibit, because I didn't have access to a color copier at the courthouse when I made my appendix.
haven't we said in the past that show-ups are lawful if they occur within a short time after an event in proximity to where the event occurred?
The question isn't whether at some other time the court has allowed something called a show-up to be considered to pass constitutional muster. The question is that this wasn't necessary, that this was overwhelmingly suggestive. The men were, this is like a prisoners of war, Your Honor.
I understand what you're saying, but I was trying to start with how much time passed between the event and the show-up. And you've told me now at least approximately an hour.
Well, it sounds like an hour and 45 minutes is what the court
Well,
found.
that's what Justice Link says, but I'm asking you, and you agreed with me that it was around an hour.
Yeah, well, the point is that what's significant isn't whether there's another 45 minutes. What's significant is that an operation was set up at this outside location where there was actually a reporter there taking, or somebody, a photographer from the newspaper taking photos, that there was men standing in front of a police car with its high beams on, with spotlights on them, with street lighting, with police standing on either side of them. This shows only one side. There's a police officer on the other side, and that can be seen in the appendix photos. And there were at least six cruisers there, and that this whole thing was set up and people were brought there who could have, where the reverse could have happened, that the men who were arrested, who were not going to be released, there was no intention to release them, could have been brought to the police station where two of these witnesses were, and have been, a normal lineup could have been conducted, one that would be set up to actually determine who could see what, rather than to kind of imply to these witnesses, this is, these people are guilty, pick one of them. And actually what we had was two of the witnesses did pick other people than the defendant. So you had Douglas Anderson identified Fallon New, and Gaddafi Henry identified Benaro Seng. And also, two of the witnesses were given verbal suggestions in addition to this scene, this stage scene. One of the, Pedro Garcia Cardona was told that when he was being brought there, that one of them was the one who shot, that he was going to see the four they arrested, and one of them was the one who shot. That's not what you're told in a lineup. That's not what you should be told if you're trying to figure out, can these witnesses identify somebody? That's suggestiveness to a degree that makes any identification unreliable. In addition, Fernando Badillo was told that they were going to line up the person. He was going to identify whether this was the shooter, but they told him they were going to line up the person. And that was that witness is involved in another issue where the defendant was not permitted to impeach on some very important bias evidence, which is that this person had a charge against him of mayhem, which carries a 20-year maximum sentence, and he had a reason to want to please the police, and the trial judge did not allow that there to be cross-examination on that issue. In addition, he was on probation because after this show-up, he pled guilty to that crime, and he was on probation, and he had reason to curry favor with the prosecution at trial also.
Are you speaking about Mr. Badillo?
Yes.
Didn't he actually identify the defendant at the show-up and already put himself on the record with respect to what he testified to later?
Your Honor, he had it sounds like what you're referring to is like the Haywood type analysis, and whether he already had given evidence before he had reason to curry favor, but he had the reason to curry favor before he gave evidence. It's not like Haywood. It's not like something that we could exclude, where we can excuse what the trial judge did.
You mean the reason to curry favor in his mind, knowing he had done something, and he said, well, I'm going to identify it.
I'm going to
and then
help the
use it
police.
later?
They want me to identify somebody. I'm going to identify somebody. They said it's one of them. Okay, well, out of the
Were
people.
charges pending against him at the time?
Yes,
At the time he made the ID?
yes.
Yeah, in April of 06.
He was charged in April, I have it.
2006. April 2006.
April 2006. The ID, the show-up was June 2006. In addition, Your Honor, to go back to the, Your Honors, to go back to the identification that it was unreliable, two of the witnesses, and including Badillo, mentioned clothing as a way of identifying, not characteristics. Well, for instance, Pedro Garcia Cardona said he didn't see the face, and he was identifying the clothing. So you have very shoddy results for what they were trying to do, or what it appears that they were trying to do, and you have a lot of question as to whether witnesses were really actually being tested to see what they actually had, who they had seen do what.
So you're actually also objecting to the show-up at all?
Right.
And so in these kinds of circumstances where something happens, police get a call, there's a call out with a number, a license plate seen, and then it's stopped within minutes. What is a better procedure that you think is an appropriate one for police to be undertaking in these circumstances,
Well, Your Honor, in the streets. In these circumstances, first of all, and another consideration, which makes the trial judge's ruling on the motion seem nonsensical, that it was a safety issue. Their safety issue would have been served by taking the people that they felt they had probable cause to stop and arrest to the police station.
Okay.
And that's what should have happened. There were witnesses there already.
Take them to the police station, and what do you do with them there?
Conduct lineups.
Put the 4 of them in a lineup?
No, conduct lineups, separate lineups with each one.
That
No
same,
reason-
that same evening?
Your Honor, one of the things missing from
I mean, these are only, okay, go ahead.
one of the things missing from, excuse me, I'm sorry.
Go ahead.
One of the things missing from a real reliable identification procedure would be where you're telling the witnesses, we may not have any of these, none of these people may be the right person. And that's the opposite of what we have with that photo that I showed.
I understand, but when we're talking about someone, and you also might want to release someone who's innocent, you're picking up individuals. I believe all the individuals were Asian, and you want them to be in a like group at 11, they were picked up 11:15 at night. And so you're going to find like individual for 4 potential suspects.
Your Honor, first of all, they had photos of all these people, according to the testimony, that there was considerable testimony that sought to associate the defendant and these individuals that he was with a gang, and that the police knew them and had their pictures. And
I'm not unconcerned. I understand what your
actually, they
problem
could have
is.
been
I'm
shown
just trying to figure
photos,
out.
in other words.
So I'm trying to figure out, are you offering a different, better alternative? I think photos would have been a different, better alternative.
Yes. Photos would have been better if photos would serve the need to do it quickly, if you didn't want too much time to pass from the event and you thought it would be fresher in the mind of the witness, the photo, they could be shown that immediately. If you couldn't get enough other people of like appearance to do a lineup. But the point is, it's seriously an important part of a proper, reliable ID would be for the person looking at the witnesses, at the suspects, to not be told one of these guys did it. And I think that there's no way to avoid that from this show up here, the way this was conducted. And I also think that the police, this isn't one of those situations where they were going to let somebody go if a witness didn't identify them. And actually, different people were identified here. It was like, pick one of these, and they picked 3 different people. So that's what happened. And it's just the normal things we examine in determining whether identifications are proper is always, you don't, even why we have their photos, well, we tell the jury why we have their photos. They could be from various reasons. We're trying not to tell the jurors that we've got criminals here and you are going to pick one of them. That's what happened here. And it wasn't serving a purpose that was safety oriented, and it wasn't to answer questions that they had, because they felt they had the people. They had probable cause. They felt that they had the right people. So at that point, what really was going on here was like what Commonwealth versus Johnson says, quoting U.S. v. Wade, which is that this was their trial. That was their trial out in the street. And basically at the trial, this evidence of this show-up was repeated over and over. I've counted 10 witnesses testified about that. That's what the jury heard most about. So they heard that The police thought these people were guilty. We showed them in a very suggestive light, that why would the police be doing this to somebody that wasn't guilty? And they've been told about it over and over, the jury. And there's practically no chance after that, and if a trial proceeds that way without suppressing that evidence, that a person is going to get a fair trial. And I'd like to proceed. Additionally, on the Badillo impeachment matter, the judge precluded impeachment because Fernando Badillo claimed he was not affected at all by his situation with the prosecutors and the police, that his mayhem charge, he was charged with biting somebody's ear off, and he ended up with probation. He, at the voir dire hearing, he made blanket denials, and the judge believed it, apparently, and that's why he excluded the evidence, the bias evidence. That's not appropriate. That's not constitutional, all right, under Sullivan versus Louisiana. The jury's supposed to do that. They're supposed to decide whether they believe Mr. Badillo. They're supposed to have the opportunity under Davis versus Alaska and the Sixth Amendment, they're supposed to have the opportunity to hear the challenges to his potential bias. And the jury is the one that's supposed to decide. When he's making his denials, they're the ones that are supposed to decide whether he's telling the truth or not. And the defendant's entitled to that under the Sixth Amendment right to a jury trial and the 14th Amendment. To proceed to the next issue, there was a juror who came forward to the court, to a court officer, and reported having a stone painted blue thrown through her husband's car in their driveway. The police that she reported this to told her that the incident did not appear random, and as it had occurred in the juror's driveway. And the police officer asked her, well, who would do this? And she connected it with being a juror. And she's the one who reported that it was painted blue. And blue is the color of the alleged gang that the defendant's allegedly part of. And blue is the fact that the gang, the Asian boys and the Crips are supposed to be using the color blue, was repeated over and over at trial. And the juror flagged that in reporting it. And the judge, although, and this is where the cases don't help, according to the case law, if a juror says they're not, on the record, they're not biased or that they don't have a problem, we're supposed to believe it, okay? But there's multiple reasons a person might say that, and this judge actually wasn't sure. And what he did was he told the juror, if you can go back to your job, but if you have any doubts later on, tell me, or tell the court officer. And that is not what defendant's not entitled to more than that and to more certainty than that. And the judge is not entitled to deference with that kind of a finding where he's not really certain that the juror is not biased. And we can see from the plain facts of what's been reported that that was a serious problem, and we shouldn't have jurors like that on cases like this, or any case. The next issue I'd like to address is also very serious. The number one informant in the case, Fallon, he was given immunity, and the judge instructed the jury on immunity in a way that made it look that he would have to be telling the truth, because they were told his immunity meant he could not be prosecuted for what he testified to unless he committed perjury. And what he testified to was a lot of bad conduct. Being a gang member, he testified to that, and he gave all the context for the alleged offense. And what defendant asked for a normal type of Champa instruction to correct the impression that the implied representation that that the witness's testimony is truthful, just because he's cooperating and because the prosecutors believe him. And the court refused. And that's just an outright Champa violation.
The Commonwealth says that you got part of the instruction. Did you?
Was that a question?
Yeah, did you get part of the question? Did you get part of the instruction?
I don't know, I can't, standing here, I don't know the answer to that.
Okay.
Mr. Mursky, your time is up.
Oh,
Thank you.
thank you, Your Honor.
Good morning. May it please the court. My name is Jessica Langsam. I'm an assistant district attorney for Middlesex, appearing on behalf of the Commonwealth. With me is Elizabeth Donegan, who's the assistant district attorney who is the lead trial attorney in this case, and I second sat the trial with ADA Donegan. The show up in this case, well, it's a preliminary matter. Justice Fishman, at every turn, held voir dire when there was a question, took information when it was appropriate, was very protective of the defendant's rights, as he should be. And there was no error in any of his rulings, whether it was in denying the motion to suppress the show-up, in denying the motion to suppress the VHS tapes. With respect to the show-up, Justice Fishman concluded in his order, which is attached to the defendant's, in the defendant's record appendix, that the show-up took place within an hour and 45 minutes. The crime occurred just at around 11 o'clock. Within minutes of that time, Fernando Badillo, who was a customer buying batteries at that 7-Eleven at Westford and Chelmsford and Lowell, was speaking with his friend, the clerk, Carlos Urrego. They jotted down a partial license plate. They got it right except for, I think, 1 or 2 numbers. That was, the Lowell police were called. That number was given. It immediately went out in a priority 1 tone to all the cruisers where there was radio silence. Within minutes, a cruiser had seen this black Honda with this license plate, followed it, turned on the lights to stop it, and eventually pulled over at the corner of Queen and Branch where there's a parking lot. And the 4 individuals who were in that car were removed. So that not only was this a car that met the description of the car that the shooter had fled in, the victim died at 11:16 that night, which is while the show-ups were going on. So we've got a serious public safety issue where we've got people with a gun who just killed somebody driving around. And when the police stop the car and take these 4 individuals out of the car at gunpoint, a loaded gun, the loaded gun that the defendant, Jerry Meas, used, is found at the feet of the juvenile in the back seat on the passenger side. There's a round in the chamber, and there are rounds in the magazine. The front seat passenger, Yun Che, who had been on the other side of the victim's car at the 7-Eleven, he was found to have a serrated knife, a steak knife in his pocket. A bullet casing from that gun was found underneath where the defendant was sitting, which is behind the driver in the back seat. And the defendant had been pulling at his bandana, probably to get it off, because it was dark blue, which is the Asian boys, the ABZ color. So clearly there was good reason this was not an unnecessarily suggestive ID. And the ID comported in all respects with this court's case law as set out in Phillips and Bowden and all the other cases. And Austin, which is a case that was involving the bank robberies.
Am I mistaken? Do I understand that some of the witnesses actually were brought to the side of the show-up from the police station?
Yes, Your Honor. I believe there were 2 witnesses who were brought to shore from the police station, and I think those were the individuals, Vishet San, who was the victim's friend, who was seated in the front seat and then ran around the car, pushed the victim to the front passenger seat and drove him to the hospital, and the victim's niece, Vanica Penn, who was seated in the back seat. I believe that the detectives had gone to the hospital, took them back to the police station. And then when the show-ups were being done, brought them to the show-ups. So the show-ups were conducted right there at the corner of Queen and Branch. Given the exigency and given the public safety issue, I would submit to court there was good reason that was entirely appropriate.
I'm having a disconnect, and I hope you can help me with it. I thought you said that shortly after the incident happened, store clerks, they got together and they came up with a partial plate and a description, phoned it into the police, and within a couple of minutes, the defendant's car was stopped.
That's correct, Your Honor.
So why did it take another almost hour and 45 minutes to have the show up?
Well, Your Honor, the first show-up, which was an individual named Douglas Anderson, took place at 11:10. So the shooting occurred at just about 11 o'clock. And the police brought all of these people in separate cruisers at different times, so that obviously none of the witnesses would either see or be affected by the others. The next show-up was Mr. Badillo, who was there buying batteries, who identified the defendant. That was done at 11:20, 11:35. Mr. Garcia Cardona, this is a man who was living in his van, which was often parked on the far side with your back to the 7-Eleven. There was a camera, and that issue came up with respect to the missing VHS angle. There was a camera that was positioned facing the payphone and the vacuum. Mr. Garcia Cardona's van was parked there. Vishas San, he was the victim's friend who was in the car. That was at 11:53. And then finally, the last individual who was brought to the show-up was Vanica Penn, the victim's niece, and that was at 12:15 a.m. So I think for those reasons, that's why the show-up took the amount of time that it did.
Now, Mr. Mirsky tells us that the police informed the witnesses that they were that they had the shooters and they were to pick from the suspects to tell them which one was the shooter.
Your Honor, my recollection of Justice Fishman found that the only person for whom that would hold true was Vishas San, who testified at the hearing on the motion to suppress that the police told him he was going to go look at some guys, I think, who the police thought did it. That was the only person. And it might be, my recollection of the transcript isn't exactly crystal clear, it might be that at trial, these other individuals that counsel referred to said, this is what they told me. But Justice Fishman found, based at the testimony that was presented at the motion hearing, that it was only Vishas San. And where all of these individuals were given this show-up identification form where you had a box for each of those rights. You're going to be shown some individuals. We don't know if they did it. It's important to clear people as it is to identify the person who committed the crime. All of these things that are set out in Silva Santiago and then again in Walker, as this court has explained, those advisements were all given to these individuals. And the advisement forms, many of the advisement forms were entered into evidence. The issue regarding Mr. Badillo. Mr. Badillo was impeached with his conviction on cross-examination by defense counsel. The question...
But not on the question of bias.
The question, exactly, Your Honor, was...
Just on the question of credibility.
On the question of, right, so on cross-examination, after the whole thing, Attorney Callahan, Attorney Daly, these terrific defense attorneys said, and aren't you the same Fernando Badillo who was convicted of mayhem? Yes. And assault and battery, serious bodily injury? Yes. And assault and battery? Yes. And that's where it lay. There was, before Mr. Badillo testified, this issue had come up before, and Justice Fishman held a voir dire prior to Mr. Badillo taking the stand, where both parties inquired of him, as did the judge, as to whether or not at the time of the crime there was any thought in his head about his own case, and he said no.
Well, isn't that for the jury to decide? I mean, why couldn't counsel then ask, and these charges were pending against you on the evening that this took place when you identified the defendant, weren't they?
Well,
and they were disposed a couple of months later with the sentence of probation, weren't they?
Well, Your Honor, it's within the judge's discretion to make this determination, but I think the jurors...
Where does that come from, the statement you just made?
That it's within the judge's discretion to make this determination?
As opposed to Davis versus Alaska, which seems to suggest that it's an absolute right.
Well, actually, Your Honor, in Davis versus Alaska, during that voir dire, that was the case where some individuals had stolen a safe from the bar in Alaska, and it was at the base of the witness's driveway. This young man, who was a juvenile, had seen these two men with the safe, and he said, and I think this was done at a voir dire in Davis versus Alaska, he said, I was worried they thought it was me because he had had some involvement in breaking into hotels, something like that. In this case, when the voir dire was done, Mr. Badillo he wasn't ashamed of what he did. He just had no concern, and Justice Fishman concluded that he was being truthful. And with respect to Your Honor, Justice Cordy's question, based on the dates, I think the jury could have determined that. The counsel said, and in May, you pleaded guilty to these crimes, didn't you? Yes. So the jurors were aware that this crime had occurred in June 13th of 2006 at around 11 o'clock at night. And while it wasn't clear when Mr. Badillo was charged, it was clear that at the time that he had pleaded after the crime had happened, and presumably after he had already spoken with the police.
It just can be a little more effective when you pose the question somewhat differently. These were pending, you faced a 20-year sentence at the time that you made this, and indeed shortly thereafter you pled guilty and you got probation, isn't that right? Wasn't that on your mind at the time you made this? Didn't you want to make sure that you had friends in the police department when your case came up for disposition? It's just more effective, it makes the point quite clearly.
And it would make the point quite clear, but I think in
And
the...
he could say, no, I wasn't even thinking about that. Well, wouldn't that be for the jury to decide?
It could be. Here, there was just simply, based on Justice Fishman's voir dire, there was no factual basis to conclude that Mr. Badillo was biased at all.
Yeah, are you saying that the question, and you may be right, but are you saying that the question of bias really, under Davis versus Alaska, really goes to bias at the time of the testimony, not at the time of the ID?
Well, Davis versus Alaska does talk about, in Davis versus Alaska, this was an individual who was biased from the outset. So I think...
Yeah, but that doesn't answer my question.
Yes.
When does the right attach? When does it become absolute? When does the right become absolute to question a witness on the matter of bias? Is it at the time of the testimony being given by the witness?
I would think that it is.
In not at the time of some prior event, such as the identification, after which the defendant, the witness pleaded guilty or whatever, and he got his case disposed of. His case was disposed of at the time he testified in this case.
His case was disposed of on May 25th of 2007. So he was charged in April of 2006. The crime happens in June of 2006. He pleads guilty and gets probation in May of 2007. And December of 2008, here we are at a trial in this matter where he testifies. And the jury hears, not with respect to bias, but they do hear that he was convicted or that he pleaded guilty of these crimes. And this was a reason, where the jury already heard that, this certainly was a reasonable limit on the cross-examination.
Could we, wasn't Mr. Badillo also, the defendant, I think, seems to be saying that the Commonwealth, having lost certain exterior video, which could have been used to impeach Badillo as to where the shooter came from. I'm not really sure I understand all of the issues relating to the video, some of the exterior, some of the interior. I wonder if you could clarify that and also just relate this to, is this another way in which Badillo was not properly able to be cross-examined?
As the short answer, Your Honor, no, it was not. But very briefly, with respect to the video, there was an interior digital color video surveillance system, and then there were VHS, which was black and white. And the 3 VHS cameras were with your back to the 7-Eleven, standing at the door of the 7-Eleven. There was one camera that went straight out the front door. There was another camera with your back to the 7-Eleven that was to the left over the payphone and the vacuum that Mr. Sean Gannum, who owned that 7-Eleven, had said that normally it faces a gas pump, but because the Boston police were doing an investigation, they asked him to turn it there. And it was turned there at the time of the crime. And then the third VHS was on the right-hand side of the 7-Eleven looking at the gas pumps. I think there was a lot of confusion with respect to what had been preserved. Lowell Police Sergeant Joseph Murray went to the 7-Eleven afterwards and was there until about 4 o'clock in the morning speaking with Mr. Gannum. Mr. Gannum showed Sergeant Murray the interior and the exterior VHS. He gave Sergeant Murray a VHS tape that had a split screen, all 3 of those black and white VHS on one videotape. Sergeant Murray also looked through all of the interior videotape of the aisles and the chips and the freezer section and only chose camera angle number 6, which was above the clerk's head looking at the people who were in line. So after all of this came out, Justice Fishman finally concluded that there had been no loss. I mean, the Commonwealth had failed to, and the police had failed to preserve those other interior angles, but they had never obtained it in the first place. And Mr. Ganem, on a voir dire, explained that, in fact, when he saw, I think, the original DVD of the color interior, he recognized that, oh, yes, I only gave the police that number 6. So there was never any issue with respect to lost evidence of the digital color internal video. The only evidence that was lost was in the night of the crime when that VHS was taken back to the Lowell police station. Detective Latham went through it, tried to break up the split screen so that you could have a continuous stream of viewing from each camera angle, and chose the parts that were most helpful to the investigation, which were cameras, the camera going through the front door and the camera on the right, which I believe showed the black Honda leaving the parking lot. So that was so there was missing evidence in the terms of this third camera angle was lost, and it was actually unknown to the assistant district attorneys who were trying the case that this third angle had been lost up until the time that we were doing the voir dire on the possible missing interior surveillance cameras. So the defense position was, look, this angle is lost, these other 2 angles are edited, we don't know what was on there.
Could you just clarify, did the police delete that?
Your Honor,
How was it lost?
it was lost because in that night of the investigation, my understanding, and from reading the transcript, is Sergeant Murray brought that VHS tape back. They're in the Lowell police station. Detective Latham puts it into the computer. He's trying to look at a straight stream of video, breaking up the 3 different pieces. He testifies at the voir dire, Detective Latham, that someone handed him the VHS, he puts it in the machine, he works on it on the machine, and he hands it back to that person. There was a lot of time spent on, and individuals were brought in fact, 2 individuals were brought in from the Lowell Police Department testifying about the manner in which evidence is maintained at the Lowell Police Department, or why evidence was missing. And this VHS tape was never found. There was a portion of that evidence log which was admitted into evidence, and the rest of the evidence log was, in fact, the entire evidence log was copied in color and was admitted for identification, and only certain pages were admitted into evidence. And those certain pages showed that the tape, that someone had gone through the box at some point, which the defense witnesses from the police department testified that's very unusual. You don't see that in an evidence log that went through, I think the exact, went through the box, tape not found, that was unusual. So I guess what I'm trying to get at is, while it might have been that this third VHS angle that was pointing toward the phone and the vacuums could have been used to impeach the testimony of Mr. Badillo, who said that he saw the shooter and the black car come from that left side if your back is to the 7-Eleven. But the defense didn't show, and Justice Fishman found this, the defense never showed that any of this missing evidence could have led to something exculpatory. And in fact, the defense, I would submit to this court that the defense really got more out of these missing portions of the tape than they would have had we had the tape. And counsel brought in these 2 police officers, showed that the Lowell Police Evidence Logbook was not in the proper order that it should have been, got a Bowden instruction, got a specific instruction, and that's at transcript December 15, 2008 at page 130 and going on, that if the jury believed that the police destroyed, concealed, condoned, or participated in the destruction or concealment of the original VHS tape, they could draw an inference unfavorable to the Commonwealth. Attorney Callahan argued that this was part of a cover-up, that the police never followed the initial leads, and so the loss of the tape was well used by the defense, and the defense was not prejudiced by the loss of this
When you
tape.
said they got a Bowden instruction, did they get a Bowden instruction or did they get a lost evidence instruction?
They got a Bowden instruction, Your Honor, and they also got this specific evidence about the specific, jury instruction regarding this lost VHS tape.
Okay.
And the Bowden instruction is at December 15th, 2008 transcript at page 131. And just briefly, with respect to counsel mentioned that there were other individuals who were picked out. The judge also instructed the jury. There was an individual, Mr. Douglas Anderson, who identified Fallon New as the shooter. That That was not admitted substantively. That was only admitted to show that the police didn't follow up on certain leads in the investigation as part of the omissions in police investigation argument that, and why he got the Bowden instruction. So the only person who identified that came in, and Justice Fishman instructed the jury with respect to that at December 15, 2008, page 116. So the only person who there was testimony about who selected somebody else was Mr. Gaddafi Henry, who picked the juvenile in this case, Benero Sang. That was the individual who was seated in the backseat on the passenger side where the gun was found.
Can I ask you about the Champa instruction? Why no Champa instruction for an immunized witness?
No Champa instruction for this immunized witness, Falla knew, Your Honor, because there was no promise. Falla knew when he pleaded guilty to accessory after the fact, years before the crime occurs in 2006, and we're here at trial in 2008. Mr. New had pleaded guilty, and there was never any thought at that time that he was going to be a witness in this case. The only promise—
there was no agreement for an exchange of truthful testimony?
That's correct, Your Honor. There was never any agreement. There was never any recorded agreement like in Champa, nor was there any other agreement that Mr. New had to provide anything. In fact, I think the ADA Dunnigan had said on the record that we weren't quite sure what he was going to say.
So why was he immunized? They needed his they were curious, they needed his testimony?
Well, Falla New spoke with the police afterwards and gave them a lot of information about the crime. He pleaded guilty to accessory after. I think he got 2 to 3 years. He had served part of that time. He was on parole. He saw the defendant shoot the victim, and he testified to that.
If he pleaded guilty, what was he immunized for?
Well, Robert Normandin was Falla New's attorney and had been his attorney from the time that the case started in the district court. And he, once Falla New finished serving his sentence, there was some effort to find out where he was. I don't think he was in the Commonwealth. Once the Commonwealth found out where he was, learned that he was willing to speak with us, put him in touch with his lawyer, and his lawyer said, no, possibly he could have been charged with some crime related to the gun. His lawyer was not going to let him testify.
Good
absent
lawyering.
immunity. Exactly. So Falla New was immunized. There was no promise. And so that's why a Champa instruction was not appropriate for this and wasn't given. And Justice Fishman, again, was very careful, held hearings about this, concluded that no Champa instruction would be given, but also in the final charge gave the same immunity instruction that he'd given when Falla New testified, and said that the jury could also consider whether the witness has been promised a benefit that may have induced him to testify, and that's at the December 15th transcript at page 128, in addition to the regular jury instruction on credibility. So I see that my time is up. I would ask this court to affirm the judgment of conviction for the murder of Bonladi on June 13th of 2006.
Thank you.
Thank you.
All rise. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting at Boston within and for the Commonwealth, at present depart, and sitting in this court is now adjourned. God save the Commonwealth of Massachusetts.